My plan is to hide, to avoid, but if I get busted, if I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi. If I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi. If I get captured, I'm not going to do a Rambo, I'm going to do a Gandhi.
Hi everyone, it's Sunday, September 24th, and I have a post here in the Free Schaeffer Cox group from Ray Southwell. It's called In Support of Schaeffer Cox number 21. As I continue down my path to understand the corrupt conviction of my friend Schaeffer Cox, it becomes more clear on how weak his conviction is. I fully understand the motivation of Department of Justice Attorney Stephen E. Scrocky's behavior prosecuting Schaeffer. Nothing to do with justice. Rather, all about his recognition and possible advancement on his legal career. He has applied for a vacant federal judge position. He enjoys blowing his own horn. I recently read a news article about how great he was, which in fact was generated by his own letter written to a reporter. Google's Stephen E. Scrocky Boston Globe Schaeffer. Schaeffer was originally arrested in March 2011 on weapons violation. He would not accept guilt and refused a plea deal. He understood it was the Commerce Clause that gave power on such issues to the federal government. He believes in states' rights. Weapons manufactured and sold in Alaska are not under federal jurisdiction. Scrocky was desperate because he did not want that issue to go to court in Alaska. By January of next year, Scrocky added on the more nebulous charges of solicitation and conspiracy to commit murder. Scrocky had done a good job manipulating the press and distorting who and what Schaeffer was and his beliefs. Mr. Scrocky had manufactured the consent for conviction through a jury far from Fairbanks. But we should not focus too strongly on Stephen E. Scrocky, for overall the behavior of most senior federal prosecutors in the Department of Justice are all the same: large egos and winning regardless of justice. Along came public defender Michael Filipovic. For years, Schaeffer has attempted to hire or find a public defender or attorney who understood the situation in his case. Never enough money, and public defenders rarely listen. Mr. Filipovic is different, so he digs deep into case law to demonstrate the many avenues to free Schaeffer. He has not chosen the issue of withholding exculpatory evidence, as it was in Senator Ted Stevens' corrupt conviction. But it is hard to prove unless a whistleblower comes forward, as one did in the Stevens case. So, he approached the most damaging conviction at present, after getting the solicitation charge dropped: conspiracy to murder. According to the attached, there are 5 elements the prosecution must prove for a conspiracy. Please listen to the attached 10-minute presentation from attorneys who teach at the government's own Federal Law Enforcement Training Center, FLETC. And then he gives the audio. According to the presenters above, legally, a conspiracy exists when 2 or more persons join together and form an agreement to violate the law and then act on that agreement. The 5 elements for the crime of conspiracy. Number 1, 2 or more persons who, number 2, intentionally, number 3, make an agreement, number 4, to violate federal law, number 5, commit some overt act in furtherance of the agreement. Schaeffer was a militia leader of many. How many of the militia members were part of this grand conspiracy to murder? Can anybody name me one? What was the date and time that these two or more conspirators were going to commit some overt act in furtherance of the agreement? Question mark. Perhaps Aaron Bennett or David Luntz can tell us. Or, better yet, maybe self-proclaimed badass, quote, Bill Fulton or his book writer Jeannie Devon can share with us all. Ray Southwell, Nikiski, Alaska. Thanks for listening. We'd love answers to these questions. Have a nice day.